Let's check out.
There she is.
And we need Miss Simon.
Oh, all right. We have something on the Karen Reid. Let's switch over.
They're not
questions
stopping the timer
by
when they interrupt.
instruction to a voir dire jury. We don't want you to disclose why you reached a result or the content of your processes, but we want to ask you about a result. Did you vote on count one? How did you vote?
You seek to impeach the.
All right, let's start from there.
Commonwealth of Massachusetts. Court is now in session. Please be seated.
Let me boost this so that you can hear it.
Okay, good morning, Madam Clerk.
SJC 13663, Commonwealth versus Karen Reid.
I'd have spat chips if Bev was on that panel.
Chief Justice, Associate Justices Martin Weinberg on behalf of the appellant.
He is the attorney that supported her for the double jeopardy hearing with Auntie Bev.
Today's appeal goes to
Weinberg.
the core issues regarding double jeopardy protections that safeguard defendants, in this case, Ms. Reid,
Defendants.
from the risk of re-prosecution for the very same offenses for which a prior jury was discharged without manifest
No CCs
necessity,
available.
without her consent. And we now know, based on the representations of 4 jurors, indirectly a 5th, no contradiction from any of the 7 or 8 other jurors, that there is a trustworthy, corroborated, and we can test uncontradicted showing that the prior jury reached a unanimous decision to acquit Ms. Reid of 2 of the 3 charges in a multiple count indictment that she was tried on in Norfolk County. I want to first.
What is the factual basis for your assertion that the jurors who contacted the DA's office are different people from the ones who contacted yours?
I don't have a basis to.
Okay, so when you say 7 or 8, that's speculative?
The numbers are that 4 of the jurors directly contacted the defense. A 5th, there was indirect proof
Sure.
that a 5th juror contacted the defense. A juror who could have been one of the 5 or could have been one of the 7.
Okay, so you're not representing that it's more than 5?
That's correct.
Okay.
What I am contesting is that there was no manifest necessity for the mistrial, which
The
is
jurors
issue 1.
themselves
There was no
are
consent
contesting
issue
that's
2,
more than 5.
and that this court's
Yeah.
jurisprudence strongly suggests that the defendant has met her burden of production and is therefore entitled to a post-trial jury voir dire by the trial court, at which we contend the probability, if not the certainty, that that voir dire would result in proof that there was a final and binding.
So Weinberg, you jump all the way to acquittal, correct?
Yes,
Under Rule 27, the verdict has to be unanimous.
yes.
It has to be a general verdict returned by the jury to the judge in open court. And then the second element, the jury has to file a verdict slip with the clerk upon the return of the verdict, which is a written recital of that same verdict. Here, none of those elements were met.
Correct.
In the face of the juvenile case, in the face of Taylor, how is this an acquittal?
It's less a matter of labels. I could call it, Judge, a unanimous
Well,
decision.
you cite Taylor, which is the case in Quincy where the judge, basically there was a procedural defect in a complaint, and the judge, for lack of a better term, pulled the plug on the case, and we had to decide what was that. Was that procedural error, or was it a judgment on the merits? And we decided whatever the judge said, it was a procedural error.
Yes.
That case is an opposite to what the situation. So how do we say it was an acquittal without a verdict in open court and no verdict slip?
I
How do
think you
we-
say that there was a
how do we
unanimous
cite case law if
decision
there is
made
none?
by the jury that's
Yeah.
subject to the proof that would come from a post-jury voir dire. I don't contest that this court should just impose an acquittal and substitute a verdict because.
Yeah, he wants
of
to interview the
declaration.
jurors.
That's a double jeopardy claim, right?
Yes, it's at the core of double jeopardy that if we can prove, and I suggest we've more than met the burden of production of proof, more than many cases where this court has remanded for jury voir dires, that if that jury voir dire established, which is what we contend it would if ordered, that this was a final and unanimous decision made by the jurors, but they didn't announce it.
The post-verdict inquiry is usually or exclusively limited to extraneous information in front of the jury.
Yeah, how
Terms of
about this
racism in the
extraneous
jury room.
information? Judge Bev didn't Poll
Do
the
you want
jury.
us to carve out a new exception to that rule?
I think it's an extension of prior precedents. Fiddler talks about not establishing inflexible rules that would expense justice.
We'd
the
both
price
fail
of
at this, Abby.
certitude. In
We should be
Fiddler,
back
there
chatting
was
the
evidence
panel.
from the jurors that there was
Yeah.
evidence received by a jury that didn't come from trial evidence. So that was,
Doesn't Fiddler caution to not inquire into the, to not to intrude
Doesn't look like
intrude
it's
into the
going good.
sanctity of the deliberative process as well?
it does.
His
Absent
voice is very
extraneous
soothing.
influence.
It,
But the influence in this case is not extreme.
They're like interrupting him. Let the guy frickin' speak.
That occurred, correct?
I
Well,
would
they're
argue that
supposed
it
to.
has to do with the results of those deliberations. And
What
the
I'm surprised
carefully
is they're
set
not
of questions
stopping the
preceded
timer
by an
when they interrupt.
instruction to a voir dire jury. We don't want you to disclose why you reached a result or the content of your processes, but we want to ask you about a result. Did you vote on count one? How did you vote?
You seek to impeach the written communication by the foreperson, correct?
I'm sorry,
You
Judge.
seek to impeach the written communication of the foreperson, correct?
I wouldn't, I would say that the recent jury declarations demonstrated that there was facial ambiguity in those communications. Yes,
Yeah.
they related to a lack of unanimity, to a deadlock about charges.
Well,
But
very
count two by
confusing,
itself,
those
read
verdict
vertically,
forms.
had multiple charges. Horizontally, there were 3 separate counts. There was ambiguity. The trial court didn't realize it. The trial court erred in not allowing what Taylor and Stewart mandate as imperatives before there was a ruling of manifest necessity. No opportunity for a defense lawyer to make arguments about options
Mm.
to the declaration of mistrial. And I contest that there were at least 3 viable options that Stewart, Taylor, and all the cases of this court mandate be, quote, carefully considered.
Really,
Must be carefully
you've
considered.
got an exhausted jury writing this very eloquent message saying, we haven't been, we've done our best. We haven't been
No.
able to reach a verdict on any of the charges.
One juror
There's
wrote
no
that.
inkling in that
One juror.
that
The rest
they've
did not agree with him.
reached verdicts on charges, or that this only relates to the second charge, right?
Facially, there was the words charges and the words.
But again, there's no inkling of what's going to happen with this motion for new trial, right? Everyone thinks the jury's done its best. It's exhausted. It's tried every option, and everyone's resigned to trying the case again. I understand something happens later, but at least at that point, is it really a mistrial? I mean, is it an error to declare a mistrial?
I would respectfully disagree that everybody concurred that there was only
Well,
one reading of this note when the defense had no opportunity, despite the clear jurisprudence
Yeah.
mandating that they be given an
Just
opportunity.
Announce
to
the
be heard.
mistrial.
Did the defense have an opportunity when there was a discussion about scheduling after the jury was sent into the room?
After
Once
they were
the
dismissed.
judge discharged the jury, once the judge thanked them and said that the case is over, the failure to make an objection was futile. It was unnecessary.
What about the case of Como versus Enid Brown, where the jury goofed, essentially? There was a miscommunication between the clerk and the case. The jury was discharged, sent into the jury room, and then we said it wasn't error to bring the jury back after discharge to clarify the verdict.
And had the jurors that assigned or that made these representations starting the very day after the announcement of the mistrial, if they had told the judge,
I guess the point I'm asking Mr. Weinberg is there was a time period, and I get your point that it was hasty to not have consulted with the attorneys before bringing the jury in.
How about consulting with the
Be
jury?
that as it may,
What?
after the discharge of the jury, I'll talk to you later, as most judges do. The lawyers then talk about a scheduling conference and time and others. Wasn't there an opportunity at that point?
No.
for the-
They didn't
for the
know.
attorney to object?
They didn't
and
know.
say, This is what should happen. These are my thoughts.
there was an opportunity, but
trusted
not a
the judge.
responsibility. The law in this case, starting 39 years ago with Stewart, places the heavy burden on the Commonwealth, which wants to re-prosecute a citizen in the face of the decision of the first jury, to recommend alternatives to the judge. And the trial judge found consent, in part based on the failure to make an objection.
And I think we cut you off when you
Yeah.
said there were 3 things that could have happened. Could you please tell us what those are?
Yeah, one is the trial judge receiving this note, and remember, didn't read the note to the defense, didn't give them an opportunity to be heard, said, bring the jury in. The jury comes in seconds later, 30 seconds if the court were to look at the video, which has been relied on by my brother as well as the trial court. The judge could have said, I've received this note. Does it relate to all or just some of the charges?
Mhm.
That's not a coercive question. It has no capacity to coerce, the jury into redeliberating. It would illuminate the implied ambiguity, which is illuminated by the jury declarations, that there were 2
Why-
ways to interpret the note.
Aren't we Don't you think we're supposed to assess the judge's decision-making or thinking in the context in which it occurred, which includes 2 previous notes reporting impasse? You argued very forcefully below that the jury had reached
How
an
about just
impasse.
poll the freaking jury?
And for the Tui
Yeah, why not
Rodriguez
just pull a jury? It's a
decision.
real easy thing to do.
Yeah, that's
I
what they
assume you
want.
made that argument in good faith.
The argument was made in good faith.
Yes,
I-
and there was no information intervening the second time you made that argument, no additional information about the jury's thought processes between that second note and the third note.
I would respectfully suggest that when a defense lawyer asks.
I'm not asking
It
for an
was the
argument, but
day
I was going to ask
after.
you for a reference to the record to indicate anything that happened in between the third note, the second note and the third note
Yes,
that would indicate any less of an impasse between the first, second, and third notes.
yes, what happened is that.
I'm just looking for a record site.
The record is the jury went out and deliberated for several hours, subject to a TUI instruction, which is designed to encourage a jury to reach a verdict when they've declared an impasse.
Right, so I understand your answer to be there's nothing in the record to indicate that they were at any less of an impasse than they were when they sent the second note.
No, and I would contend that all 3 notes are ambiguous. The defense,
That was not the argument you made below.
the argument made by trial counsel was to argue not for a mistrial. They never asked for a mistrial.
I understand, but there
They
was
asked-
no argument that these notes were ambiguous down below, correct?
Down below at the trial court, yes, the argument made on the motion to dismiss was
No,
that there
at the
was an
time,
ambiguity.
not at the motion to dismiss, at the time.
They had no opportunity at the time.
5
First note, was there an
seconds
argument made
that the judge
concerning
gave 'em?
ambiguity in response to the first note reporting impasse?
No, there was a
Was
request
there
for
any
TUI.
ambiguity argument made in response to the second note?
There was a request for TUI. But the
Right.
only time that I suggest matters is the third note where they had no opportunity to make that
Why,
argument.
why would that be? Why would we just focus not on the totality of the 3 notes, but just the last note? Why is that, in your opinion, or actually citing any legal authority, why would that be the critical moment?
Because before that, there's at least an impasse on one count, and there is no obligation on a trial court in terms of timing when to seek a partial verdict. When Judge Descasiano asked me for what the 3 alternatives are, one of the alternatives was simply to ask the jury what it meant. The second was to apply Rule 27B, which says before a mistrial, a court may request of a jury whether or not they've reached any decision on any of the other counts. The reporter's
What-
notes.
At the moment of the declaration of the mistrial, what suggested in the notes, the 3 notes, that there was any agreement as to any of the 3 charges?
Facially, they said
Nothing.
they were at an impasse, and the court has an obligation to carefully consider all alternatives under Taylor and Stewart. There's no evidence on this record that the trial court made that consideration.
Well, after the first note, she asked counsel and the prosecutor, what do you think? And I thought defense counsel argued they've exhausted their review of the evidence, and so give the Tui Rodriguez, and the prosecutor said, not yet. And she said, yes, no, not yet. And
The
then
Tui
there was a second
Rodriguez
note where-
is the Massachusetts version of the Allen charge.
again, they report that they're in an impasse quite eloquently. And again, at that point, the prosecutor says, don't give the Tui Rodriguez. And the defense counsel says, yes, go ahead and give Tui Rodriguez. And she considers that alternative and gives the Tui Rodriguez instruction.
Yes.
Now we have the third note. We've really tried on all the charges. Some of us agree that beyond a reasonable doubt, that the elements of each of the charges have been established. Some of us do not. And at that point, she's considered the alternatives. Let them continue to deliberate, give the Tui Rodriguez, and the third time, it
She-
sounds like that everybody's in an impasse. That's all the information she has.
And that's part of the perils of not providing counsel with an opportunity to be heard, which is what was required. Because we don't know that the jury notes 1 and 2 didn't also relate to 1 rather than 3 counts. What the defense wanted was a verdict. If you want a mistrial, you ask for
So
one.
your rule
asked-
would be that anytime there's more than one charge, the judge must ask, when the jury reports back that they're in an impasse, the judge must then ask, well, are you at an impasse as to
On
count 1?
every
Are
charge.
you at an impasse as
Yes.
to count 2?
Yes.
As to count 3? That's
Correct.
the rule?
When there's a multiple count indictment,
Yes.
that's the rule as described by the reporter to 27B, which is a trial court must
Yes.
make that inquiry
I thought-
before ordering a mistrial.
I thought that it was a May, Mr. Weinberg.
The may was in the rule. The reporter's note says must. I would argue the may relates to timing. In other words, there's no obligation of a judge at any particular time to ask the jury whether there's a partial verdict. But if you're going to issue a mistrial order, that's where the must comes in.
In the ordinary case, the foreperson will say, we've got a verdict on counts 1 and 7. and we seal them, and then we continue on, and we can
But
mistrial.
there was only one
That's
verdict form,
correct.
not three.
When you say it wouldn't be coercive to ask, am I right to assume that you're relying on Rule 27B?
27B and the distinction in the Roth case, which is there is a risk of coercion if you're dealing with a single count with multiples. But 27B preempts that in terms of the importance of a mistrial order.
And your argument to Justice Wendlandt, and I guess to me as well, the court, is that that is not discretionary.
My argument is that that given the core values of double jeopardy, that unless the defense consents to the mistrial order, the court has to comply with the guidance, the principles, the mandates of Stewart and Taylor. And here they complied with neither one of them.
And that's absent any other evidence as far as the deliberations go, and notes that there's agreement, or at least partial agreement, on a particular verdict.
Yes, those notes were subject to one of two interpretations, and given
That's
the
us.
obligation of a trial court to consider all alternatives, including the alternative post-TUI of seeing whether the jury wanted to deliberate on any one of the three counts, which is part of the statute. I think it's 268-34C. That's a third alternative. Here, the problem is the record doesn't reflect the trial judge's consideration.
As a matter of
of these
fact, were there
alternatives.
3 separate verdict forms?
No.
There was actually more than 3 verdict forms, because the verdicts on count 2 had multiple. They had
But,
3
so
different
count 1 and 3, were there separate verdict forms for those?
I believe there was separate forms, but there was, guilty, not guilty, count 1, count 3, and count 2. There was supplemental instructions and an amended verdict form to make sure the jury had options that were consistent with the law of the SJC as to how you deal with lesser includeds.
Can I ask, sorry, so I'd like to ask how the judge says she can't ask the questions that you're saying she could without interjecting herself into deliberation. So let me read what she says. While the defendant contends that the conflict is reflective of the fact that the instructions given to the jury by the court were confusing, determining whether this is true would necessarily require inquiring into the back and forth among the jurors during deliberations.
You could have
Can you
just
tell us
polled the
how?
jury. You
Yes.
can poll them now.
How
Yes.
would she do that?
Yeah.
She doesn't envision a way that she could ask the questions you're talking about without requiring them to explain whether they took votes, how they took votes, and what the votes were. Just tell me what your thought process is on
Well,
that.
my thought process, one, is that this court has the option of essentially informing the court what questions could be asked. And 2,
But
if we're
again, they're
gonna
going to require follow-up questions. And unlike
Just
extraneous
poll the
influences,
fucking jury.
you can say,
Yeah.
"I
Oh my
really want to inquire about whether
They're like
this
overcomplicating
is
it.
state
I
vote or
know, but
something to that
Judge,
effect.
but
This is
that
what
link you
they
just
have
showed me
to
will show
require
this next.
what their votes were,
We're trying
how
to protect
solid
her.
they were.
Mhm.
Isn't that going to get into deliberations inevitably?
I think you can ask about the results of deliberations. I would design it by saying an instruction to the jury to not disclose the content or your processes of deliberation. But I want to ask you the following questions. 1, did you take a vote on count 1? What was your vote?
Yes.
Was the vote unanimous amongst other jurors? Was the vote final? Was it ever reconsidered or
That
rediscussed?
question, is it final? Isn't that going to, the jury can change its mind, right?
Could, but there's no way.
But isn't that going to result in asking that type of question? When you say final, but if you don't get your way on 2, is it final?
Was it ever reconsidered? My contention, based on these jury declarations, based on the voicemail, based on the fact that in this highly publicized case, no other juror who they served for months says to anybody, to the court, to the clerk, to the court officers, to the prosecutor.
Well,
"Wait, I
they
didn't
also
agree."
don't write in saying we agree with the other 5 or anything to that effect. They're silent, as their deliberations are supposed to be silent, right? So
But it's an
Because they
almost
should have been told.
unprecedented meeting of the burden of
Mhm.
production. If this was a Sixth Amendment issue, the jurisprudence of the court would compel a post-jury inquiry. The Fifth Amendment values are just as important. Questions can be designed, whether it's final or was it ever reconsidered, that would demonstrate what we contend. These were final votes. This was the end of counts 1 and 3. It's exactly what juror D says. We went to the bus and says, no one's ever going to know that we
But
voted to acquit.
Isn't that part of the problem? And isn't that what Bluford counsels against? Because you keep saying that whatever was done on counts 1 and 3 were fixed. And despite the fact that there was potentially still some uncertainty about where the folks were on count 2, that could never change in the continuing deliberation about count 2. And isn't that what Justice Roberts was talking about? The deliberations weren't finished. They weren't finalized. And you keep using that term. But there's still opportunity for folks to change their positions in the context of the continuing deliberations on count 2 and its lesser included. So what's your best authority to say that it was fixed for all time and for all deliberations, and there was no opportunity, particularly when we don't know that no one, to Justice Kafka's point, has called and said, hey, me too, we believe the same thing, for the court to say that this is what it meant for all time.
So, and the answer to the question, and I understand the question, in the Bluford case, we had the return under Arkansas law, which prohibited partial verdicts. The jury said that they'd reached a decision, they would send out again, and then they said they had changed that decision and were at an impasse. In this case, a post-jury voir dire can ask about whether or not you took a vote. Was it unanimous? That doesn't intrude on the values of 606B. Was the vote ever reconsidered? Was it final?
But that's my point. If you stop right there and say that's the end of the inquiry, that's really not true, because there's still deliberations that are left on count 2 that might inform a juror's change of position on count 1 and 3.
And that could be the subject of a jury inquiry as to whether or not the unanimous vote.
Get past
that
the
acquitted
first
Ms.
bit
Reed of murder
first.
And leaving the scene was ever reconsidered. You can ask for a result without probing into a mental process, into the content of deliberation. The values at stake here are too important. Yes, in the
Yes,
McCallum
oh.
case, we allow a court to ask about mental processes. Was there this communications of bias? In Fiddler, they talked about the communication of evidence that wasn't received through the gatekeeper function of the trial court. This is important. Ms. Reed was acquitted by those jurors, and we should have the opportunity, or not acquitted, we contend, a unanimous vote. We should have the opportunity to have Judge Cannone conduct a voir dire. It's done
Yes.
when
They
one
just
juror
added to his
says
time.
there was a statement of bias, when one juror says there was
Yeah.
contact with
Right,
an
but when
external
it's an
source.
extraneous source, then you need not get into deliberations. But as I listen to you suggest questions that the trial judge could have asked, it seems to me those questions go directly to the jury deliberations.
And I would contend they go to the results of the
Really?
deliberations. They
Yes.
do not require a judge to ask, why did you vote not guilty? What led you to vote not
So
guilty?
the question
Did you
asked
vote
to
not guilty?
juror F would be, was that vote final?
Yes.
Juror F's answer would be, well, no, it kind of depended on how I would have voted on count 2.
Oh my
We were not
God.
yet, we were not yet done.
And that would reflect two
It's a
things.
jury deliberations, right?
That would reflect that the voir dire by the judge did not lead to a result of a final unanimous verdict of not guilty. But to foreclose those inquiries when there's a real
There we are
possibility
again.
12 jurors are going to say to Judge Cannone, if conducted, that was my vote. It was not guilty.
It
We never
seem-
reconsidered it. We considered her innocent. We didn't think she intentionally killed
Yeah.
anyone. We should not be foreclosed from having that option.
It seems to me that what you are in effect asking via a post-trial inquiry is to discover whether the jury disregarded the jury instructions. And the reason why I say that is that the jury were instructed to return a verdict after the final vote, and I'm using that as a direct quote of the jury. So when they had a final vote, they were then to check the appropriate boxes as to each charge, then sign and date the verdict slips. And it seems to me, or at least please correct me, why isn't this post-verdict inquiry that you're suggesting actually an attempt to try to establish that the jury didn't follow the instructions? And we have a long line of
Because the instructions were
that
confusing.
says we presume that
Yeah.
the jury follows the instructions.
And there is cases when mistakes are made by jurors, where they don't fill out the verdict slip accurately. The
That's
Capen
not
case-
this case, though.
No, this case, I think, is a stronger case for a voir
The
dire,
verdict
because
slip's
we're not
wrong.
impeaching a verdict. We're explaining a note. We're asking the jury to resolve an ambiguity within the note that the trial court didn't realize, in part because they didn't provide an opportunity for argument, in part because they used a procedure that's totally at odds with this court's jurisprudence in Stewart and Taylor. And before we get to the voir dire
Yeah.
issue, we contest there was no manifest necessity.
Okay,
and the
before you shift back to that,
Yeah.
what's the best case, best federal case? Because we're interpreting federal law here. What's the
Poll.
best closest case, and not an
Poll the
extraneous
jury.
close case, allowing this type of probing after, if we want to go back and read one case that's
It's
to do what you want us to do, but what's the closest case?
It's actually a Mississippi case. I think it's named Martin versus
That's a-
State that the amici
that's a
brief
state court
brought
case,
us
right?
to. They read the
It's a state
newspaper.
court case, right?
It is.
Any federal cases? Because again, this is a federal constitutional issue.
There are cases where jurors correct
No,
verdicts.
no federal case
This is,
that has the, you're asking us to direct Judge Cannone to do this. I just would be helpful if you have a federal example that we can turn.
I don't think there is any case law.
We're interpreting federal law, not our own law here.
this court has a long history of
Yeah, but
applying
we don't
federal
have any
constitution.
cases except extraneous influence cases.
You're-
I'm just looking, again, your chance.
You
The
do
best
have-
case that we should look at for you.
You do have one example, which is the McCulloch case, which follows a Supreme Court case and allows the jurors to disclose their deliberations regarding ethnicity and racial bias.
Again, that's extraneous influence. It's different.
It's internal to, I think it's closer to the core of 606B.
No federal case we can turn.
There's-
to.
There is no
the
case
court has
law.
the prosecutor
No.
come up
Why
with
are
a
we
case to the contrary. This showing by this jury, it's not going to open the floodgates for post-voir dire.
Well,
This is
actually,
a-
that was my question. What's the limiting principle here? It
Poll the
sounds like
jury.
if ever a juror comes back to the defendant and says, hey, that's not really what happened, then we open it up.
This would not be a case where a juror has second thoughts, is reconsidering, didn't think he or she was listened to in the jury room. These are representations by 4 jurors that were unequivocal, unconditional. They said we reached a final verdict of not guilty. And I
So the
urge
jurors submitted affidavits?
the jurors would submit affidavits. If we asked the judge, if you're not going to accept the lawyer's affidavits, please authorize the lawyers to go back to the jurors. But we didn't want to walk near the boundaries of 606B. The judge accepted the truth of the lawyer's affidavits as a substitute for the jurors' affidavits. But again, let us voir dire the jurors. The judge has the power to make a decision. Was there a unanimous verdict of not guilty?
But our review is an abuse of discretion. Why was it an abuse of discretion for her to deny you that ability?
Because the Stewart case says the deferential appellate review depends on whether or not there's proof of
They just gave them
compliance with the
another
principles set
they gave
forth
them
in Stewart,
16 minutes
meaning,
extra.
Yeah.
Did the judge carefully consider all the options?
Wow.
Did the judge give
Hang
the
on,
defense
it's
a
counting
full
up.
opportunity? These were mandates, not discretions.
It's
They're
counting
conditional
upwards.
precedent
Not
to the
yeah.
declaration of manifest necessity.
My
Simply
mistake.
wasn't followed in this case. It wasn't followed the basic rules. It's Floyd P., which is when a jury gives a note, you share it with counsel, you listen to counsel, you get their views. We don't know whether counsel would have advised the judge about 27B or would have asked the judge to ask the jury whether.
Counsel, can I go backwards on that?
Sure.
Because part of I don't know what part of this goes into the calculus, but you have 2 extremely experienced trial lawyers. No one in that room would ever think, potentially, a mistrial may be declared after Tui Rodriguez is given. There isn't any lawyer that's worth their salt that wouldn't think they might get a mistrial on this. So you know where the puck may be going when it comes to giving to Tui Rodriguez. And
Judge
you
is
say that there
equally
was no
experienced.
manifest
Would have
necessity for
told.
this and no opportunity to be heard.
Yeah.
How do we factor in that you've got to know that that's going to be on the table? Is that a mistrial? And what obligation is there on counsel to say, hey, before you declare a mistrial, let's talk about alternatives to that?
Let me address that. Judge comes in.
They've been
2
given the
years of
opportunity.
Prior practice where she gave counsel a full opportunity, announces to the defense lawyer, there's an impasse, bring the jury in. If your honors would accept the audio video that again the district
Yeah.
attorney has relied on, it's
No.
about 30 seconds till the jury comes in, but you hear a door open. Defense counsel don't know what's in the note. It hasn't been read to them.
Yep.
They don't know what the judge's intentions are. They don't know whether they'll be invited to come to the bench to discuss it. They have to be surprised they weren't given an opportunity.
Yep.
They hear a door open. The jury could come in 5 seconds, much less 30. And I stand before you with 52 years of trial experience to say no competent defense lawyer would risk the wrath of a judge or jury by interrupting that process, by making objections.
Wait,
So
the judge said they're at an impasse, bring in the jury?
bring in the jury and you can actually hear a door open.
Okay,
So
and you have
when-
30 seconds to object?
But you don't know that it's not 5 seconds. You don't know the door's not open.
Yeah.
You don't know the
You
jury
can say,
can't
Your
hear.
Honor, may I see you at sidebar?
In this case, that's happened repeatedly? No?
Here, the defense lawyers did not know what the judge's intentions were. They didn't know what was
But
in
they
the
did
note.
know that the jury had reported to her that they were at an impasse.
They were in an impasse, bring the jury in. Yes, that was possible, but to
What was possible?
to ask to go to the bench, but
Yes.
this
And
court
did that
has-
happen?
No, but neither did it happen that the prosecutor, who this court says has a heavy burden because they're the sovereign, they want to re-prosecute somebody after a mistrial, to subject them to the perils of a second prosecution. The trial court did not impose a burden on the prosecutor. They have this more of an obligation in double jeopardy law to raise options to a mistrial.
point.
And I don't think it's fair to conjecture consent or to penalize a defense lawyer when they have been relying on a procedure that's lawful, where defense lawyers have a full opportunity to be heard. They don't know what's in the note.
She doesn't need the consent of the defense to declare a mistrial. She needs to determine that there was manifest necessity for a mistrial, correct?
After a careful consideration
Mhm.
of all alternatives and after giving.
So
the
that may
defense-
explain why perhaps the judge did not inquire, was because given, I don't mean to replow the same territory, but this was the third note.
It was the third note, but it was a note that demonstrated, because of the deliberations between the second and third, that the defense didn't want a mistrial. They wanted a verdict.
Mr. Weinberg, are you aware of any cases, or can you let me know if there are any cases where the judge gives TUI,
Yep.
and then the jury comes back and says, we're deadlocked, as articulate as this jury was or not, and then the judge does something different other than just declare mistrial?
Well, the statute itself says the judge has no right to obligate the jury to redeliberate, but every right to ask the jury whether they would consent to continue deliberations. And here I
But
contest.
here, the jury said to continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs.
Yes.
Right, and in the face of that,
In the
you think give it the old college try is okay?
I think that the judge had alternatives that the record does not reflect, were carefully considered, including, is your deadlock on all three counts? Is there any, would you consent to deliberate on any count that you've not reached an irrevocable deadlock? Questions like that are not coercive. Questions like that would have actually given the illumination post July 1, and I'm not arguing that that provides proof as to what the process was.
Again,
on
In
July 1.
the statutes, again, is a may, correct?
The statute says, 27B says a court may make that request, but the Stewart and Taylor rule require careful consideration. That at minimum was an option not considered.
The careful consideration is basically all that has gone on as far as the length of deliberations, the number of notes, et cetera, and what the notes say. That's part of the calculus, correct?
Yes, the judge made her own judgment, and I'm not saying the judgment was irrational. I'm saying that she
I think
would have
it
been
was rational.
aided by counsel.
It
The
was
law
irrational.
required she give counsel
We'll
an
say it for you,
opportunity
mate.
to be heard. There's no evidence in the record she considered any option except to declare a mistrial. That contradicts the clear jurisprudence of this court, and I contend it contradicts the core protections that double jeopardy give to a defendant against being re-prosecuted, which the Supreme Court has said carries with it the risk that an innocent person can be convicted, the ordeal of a second prosecution. This court has given procedural guidance, conditions precedent. This is what the words are must. 27B may be discretionary, although we argue the reporter's note in combination with Taylor required that inquiry about partial verdicts. This court has told the judges ordering a mistrial is irrevocable. And you need to go through certain procedural conditions precedent, and the judge did not. And I respectfully submit that extinguishes the principal basis to say there was manifest necessity in this case. There was never a knowing and intelligent consent. The defendant never asked for a mistrial. And at minimum, secondly, we strongly ask this court to extend the Sixth Amendment jurisprudence, where you allow jury voir dires into the Fifth Amendment. The Fifth Amendment is as important as the Sixth Amendment, and a jury voir dire conducted by an experienced judge can determine whether or not there was a unanimous and final verdict of not guilty on 2 counts, one of which carries with it a life imprisonment. I thank you very much for the privilege of appearing before you today.
Thank you.
He killed it towards the end. I think that was a good argument towards the end.
Good morning, Your Honors. May it please the court, Caleb Schillinger for the Commonwealth. With me at council table is my colleague, ADA Laura McLaughlin. I'd like to start with the mistrial issue and emphasize a point that has been touched on through the questions to my brother, but that I think is important for the court to consider, and that is the trial strategy here. As a general matter, absent some sort of definite indication from the jury that they're prepared to find a defendant not guilty on a charge, effective defense counsel is not going to ask the judge to start probing, or not going to want the judge sua sponte to do that, because doing so runs the risk of extracting a guilty verdict and convicting your client instead of obtaining a mistrial across the board.
But what do we do with the fact that after the third note, the jury is called in? There's not, unlike the first and second note where she says, okay, counsel, let me know what you think. Here, we don't have that opportunity.
The judge did inform counsel that the jury was at an impasse, and I would argue at this point, it is clear that a mistrial is inevitable or unavoidable. The jury has twice already returned deadlocked. The defendant has argued strenuously that they are deadlocked. They've been given Tui Rodriguez, and now the judge informs counsel they're at an impasse. At that point, counsel couldn't credibly believe that the result here was going to be anything other than a mistrial. And again, in addition, just to circle back,
All right,
all the
we
more
might
so,
come
Your
back
Honor,
to this
because
one, I think.
what was their defense in this case? The defense.
This is their argument. So let's get rid of that one and go back to this one. Was it share screen? Enter stage. And play. Right, now I'm going to put the kettle on.
And final verdict of not guilty on 2 counts.
Sounds
one
very
of
low
which
to me.
carries with it a life imprisonment. I thank you very much for the privilege of appearing before you today.
Thank you.
He killed it towards the end. I think that was a good argument towards the end.
Good morning, Your Honors. May it please the court, Caleb Schillinger for the Commonwealth. With me at council table is my colleague, ADA Laura McLaughlin. I'd like to start with the mistrial issue and emphasize a point that has been touched on through the questions to my brother, but that I think is important for the court to consider, and that is the trial strategy here. As a general matter, absent some sort of definite indication from the jury that they're prepared to find a defendant not guilty on a charge, effective defense counsel is not going to ask the judge to start probing, or not going to want the judge sua sponte to do that, because doing so runs the risk of extracting a guilty verdict and convicting your client instead of obtaining a mistrial across the board.
But what do we do with the fact that after the third note, the jury is called in? There's not, unlike the first and second note where she says, okay, counsel, let me know what you think. Here, we don't have that opportunity.
The judge did inform counsel that the jury was at an impasse, and I would argue at this point, it is clear that a mistrial is inevitable or unavoidable. The jury has twice already returned deadlocked. The defendant has argued strenuously that they are deadlocked. They've been given Tui Rodriguez, and now the judge informs counsel they're at an impasse. At that point, counsel couldn't credibly believe that the result here was going to be anything other than a mistrial. And again, in addition, just to circle back, all the more so, Your Honor, because of what was their defense in this case. The defendant's defense was that she didn't cause the victim's death, but allegedly had been framed. If the jury were to come back with a guilty verdict on any of the charges, or either of the lesser included offenses, they would have necessarily had to find that the victim did cause, or excuse me, the defendant did cause the victim's death. And it would have been a rejection of that defense in the defendant's public narrative. The defendant here did not want the judge to do more.
Well, rather than speculate what the defense wanted, let me ask you about what happened. Did the judge have either the discretion or the obligation to ask the jury after the last note about continued deliberations or a verdict on any lesser included offense?
No obligation, Your Honor. Perhaps as a matter of...
Did the judge have the discretion to do so?
Rule 27B is discretionary. The language of the rule itself consistently refers to what a judge or a jury may do. I know the defendant
So
argues-
it's not inherently coercive. If
so
the judge has a discretion, it can't be coercive,
It's,
correct?
well, no, it's a matter of discretion and then consider the factors that inform the exercise of that discretion. And that's what the judge did consider here. On the one hand, the judge had no doubt based on the jury's notes that they had not reached agreement on any of the charges. Further, the jury's third note had triggered 234A 68C, so they couldn't be compelled to continue deliberating. They made it abundantly clear
Unless,
they did not
unless,
consent.
unless they want to.
Unless they wanted to, exactly. But indicated that if they were forced to continue deliberating, any verdict they returned wouldn't be a just verdict. It'd be the product of compromising their deeply held beliefs and moral convictions. You have that on the one hand informing the exercise of discretion. On the other hand, you have strong countervailing reasons that argued against making further inquiry here, which is the potential for coercion. You have a jury that has sat through a grueling 10-week trial, nearly 100 witnesses, hundreds of exhibits. Now 4 or 5 days of deliberations, they've returned 3 times indicating that they are deadlocked, they are at an impasse, and they do not want to continue to deliberate.
But counsel, I'm sorry to interrupt you on that because I don't want to miss this point. But wouldn't that go to the calculus of manifest necessity? Because all of those things seem to be the reasons why you would tell counsel about the last note and say, what do you think? Because you have gone through this 10-week trial. You have gone through the impanelment process. You've spent a lot of time, energy, and money, anxiety, and angst in this trial. Why wouldn't we talk about what potentially we could do short of saying, mistrial, let's start again?
Certainly, Your Honor. And I think, in hindsight, seeing, the quote unquote remarkable turnaround of the defendant's position, would it have been better? Would it have been preferable for the judge to take that extra step, perhaps? And another judge might have done that. But here, given the progression up to the third note, and in particular, given the defendant's response to each of those 2 prior notes, I think the judge could reasonably conclude the jury is at an impasse.
Now he's
There is
talking for
manifest
Auntie Bev.
necessity for a mistrial. There is nothing more to be done here. And in fact, in her order denying the defendant's motion to dismiss, the judge did say a mistrial was inevitable.
You can't find consent, right? If you don't ask, the consent is out the window, isn't it?
I don't agree, Your
Yes.
Honor. You can find
Yes.
consent through the lack of an objection here.
Even the burden of proof is on the Commonwealth. There's no opportunity whatsoever for the defense counsel to raise anything. I get manifest, you may have manifest necessity, but I don't see how you can get consent when you haven't been consulted in any way.
They were consulted in response to the first 2 notes. And what was the defendant's response to those notes? It was to argue in favor of doing thorough deliberation and accelerate the process at every step toward a mistrial.
But pushing towards a verdict is different from, that's different. I mean, if
Mhm.
they want a verdict, because they want Tui Rodriguez doesn't mean they've consented to a mistrial.
Even so, Your Honor, they had opportunities to object. They could have objected while waiting for the jury to enter the room. 30 seconds is ample time to at least ask, may we be heard at sidebar, Your Honor, after being informed that the jury's at an impasse. They could have brought the issue up again during the scheduling conference after the jury was excused to the jury room. And even after that, they still
And
could
she
brought
could have
it up.
told
We
them.
cited in our brief Wentis as an
Yep.
example of where a defendant lodged an objection after the fact, after the jury had been excused to the jury room. And at that point, the judge did still consider counsel's arguments. And I think given the defendant's response to the prior notes, it being clear what the defendant was advocating for here, and at the point of the third note, it being unavoidable based on manifest necessity to declare a mistrial, the absence of an objection here, or even asking to be heard, Your Honor, indicates consent.
No.
You might have, I know it probably is in your brief, but what's your best case for that?
This case is closer to Pellegrin, Your Honor. The 2, certainly where there is something abrupt that happens that is inconsistent with the way defendant has conducted him or herself, the approach that they have taken during the trial, it would be difficult to find consent. Oregon is an example of that. Judge comes in, abruptly announces trial judge is unable to preside. I'm declaring a mistrial. There was no indication there that the defendant was in agreement with that. But here, again, where you have the defendant advocating for the result of a mistrial, the ultimate conclusion of it, when it is then ultimately declared,
How do you know the defendant is advocating for a mistrial as opposed to pushing
Yep.
a verdict?
because, Your Honor, not just what they argue, but what they are.
Because Tui, there's 2 results of Tui. It's either a verdict or it's a mistrial, and it pushes the jury to its extreme. So when you say that they're advocating for a mistrial,
That's
they
not
could have
correct.
been just as well advocating the jury for that final push, as the Tui Rodriguez instruction says. You need to check yourself. One side has the burden of proof. It's very favorable in some instances to a defendant. So how can you stand up here and say that they were pushing for a mistrial?
Perhaps as to just Tui Rodriguez, although as a practical matter,
No.
as Justice George has pointed out,
No.
experienced defense
Tui
counsel
Rodriguez is
understand
not
there's
asking
going
for a
to be
mistrial.
before that
It's not.
has been given, or very likely. But set that aside, Your Honor.
Well, I think experienced counsel know that you're most likely not going to get further deliberations. But counsel also know that it could very well, it's a flip of a coin. It could be a verdict or it could be a mistrial.
Right. On top of that, Your Honor, I would point to, in response to the first note, the Commonwealth argued against a finding of due and thorough deliberation. Hasn't been enough time. Let the jury continue to deliberate. Already at that point, the defendant was prepared to argue there's been due and thorough deliberation. I think the exact quote is, "We believe there's been sufficient time." Disagreed with the Commonwealth's reading of the note from the juror that there might still be the possibility of reaching a unanimous verdict, arguing that they'd already exhausted all manner of compromise, all manner of persuasion. So, and then again, in response to the second note, again argued there's been due and thorough deliberation. Those arguments are pushing to the point where 234A 68C is triggered, and the jury cannot continue to deliberate, and a mistrial will have to be declared unless they consent to further deliberation.
I think it's safe to say that they were pushing for a 2E instruction, correct?
Yes, they asked for that as well in response to both notes, Your Honor.
Do you need consent in order to win?
No, Your Honor, there was manifest necessity for the declaration of a mistrial here.
And so absent the consent, we can just, you think the manifest necessity existed?
Yes, I don't think that the judge abused her discretion in declaring a mistrial for manifest necessity based on the jury deadlock in this case for the reasons that we have discussed and were discussed with my brother.
But counsel, we also have, and not necessarily in this context, but we have in cases where there are evidentiary issues, where we have found that the trial judge abused their discretion when they didn't utilize something that they could have. And so in the record here, where there, again, it's not necessarily prescriptive, but there's 27B that says may, there's other things that could have been done short of declaring a mistrial. Is there no calculus here that says that perhaps there could be an abuse of discretion because there's nothing to suggest that she went through the progression of what she could have done short of declaring a mistrial, which directly goes to not giving defense counsel an opportunity to say, hey, we've got all our heads in the courtroom. Let's all collectively think about this, and perhaps we can all come to some other vertical other than declaring mistrial.
Good point.
I think it's clear from the judge's order that she was cognizant of at the time of these countervailing considerations, looking to the jury's notes, the lack of any indication of agreement on the charges, balanced against the risk of coercion, the defendant's trial strategy, and the fact that the defendant had not been advocating for the judge to do something more. I think it's clear that the judge was aware of these considerations and balanced them in a way that was not an abuse of discretion. Might a different judge have reached a different outcome here? Perhaps.
Yes, probably.
But the judge's determination here, which is owed some deference, if not an abuse of discretion, was not outside the range of reasonable
At the
outcome,
very least,
given the
ask for a
jury's notes
vote.
and these other considerations, Your
You
Honor.
don't think it would have been coercive to say, come on, jury, I know you say that you're exhausted, that any further deliberations would force us to compromise these deeply held beliefs. But did you reach a verdict on count one?
I do think that would be extremely coercive, Your Honor, yes. And I would point the court to footnote 5 in Ray versus Commonwealth, where this court said or noted there may be a prevailing practice among federal courts about inquiring individually of jurors as to whether they're truly deadlocked or perhaps further inquiry, but that is not the prevailing practice here in Massachusetts and is not an encouraged practice, particularly because of the risk of coercion.
I take it Rule 27 doesn't, there's no discussion of Rule 27 at any point during the deliberations or sort of preparing for the deliberations, right? When we read through this whole record, we're not going to find any indication it was on anyone's mind, right?
Correct.
But so I see your point on the note is so compelling that they've worked this to the end. Then the problem comes when we get this new information that's somewhat inconsistent with that they've, I mean, the key sentence, some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet. Then we get this motion for a new trial with 4 or 5 jurors saying that's not the case, right? That's the troubling part. What should happen at that point?
And I do want to make sure I get to this, Your Honor. The alleged agreement reflected in those statements is not an acquittal. It lacks finality of a verdict, really for 2 reasons. One is the reason that's already...
I get that, but I'm just trying to figure out what should the judge do at that point? Because they're arguing, okay, you have some follow-up obligation here. Is there no obligation whatsoever, I guess, is what?
No, and we argued below, actually, Your Honor, that it's not reliable or competent evidence because it goes to the substance of the jury's deliberations and is being used to try and impeach the declaration of the mistrial based on the jury's notes.
The judge makes a finding that she finds them credible for the purposes of this motion, right? So she doesn't say they're unreliable, but rather accepts their reliability and then concludes that nonetheless that she can't inquire here without invading deliberations. It's different from reliability. She's given up the reliability point, right? She's made a finding that I accept for these purposes that those 4 jurors or 5 jurors
Correct.
are credible, right? So it's not a reliability issue that you can rely on, right?
Correct, but the judge also correctly or properly ruled that it would not be appropriate to conduct some sort of post-trial inquiry at this point for a number of reasons. One, this jury, a mistrial was declared, this jury was discharged. They've now been discharged for 4 months. They have no power or authority at this point to come back and render a de facto verdict.
Well, the request is to inquire of them, which we said you can do in Fiddler and McGowan et al., right?
But not to get into their
Well,
deliberations.
that's a separate matter. You said that, you can't bring this jury back. You can bring them back for a post-verdict inquiry.
Well, it's one,
Under the guidance of Fiddler, et cetera, right?
it's one thing, Your Honor, to bring a jury back and inquire as to extraneous influences to determine whether a verdict that was returned and affirmed may have been the product of other than a fair and impartial jury. It's quite another to bring a jury back to essentially construct a
And that
verdict. that
what
was never
Mr. Weinberg argues is what we protected are the Sixth Amendment rights to a fair trial, but he says we should expand our law, as I understand him, to include the Fifth Amendment right and double jeopardy protections as well. What's your response to that? Why not?
I agree with the reasoning of the appeals court in Di Benedetto that it can't simply be the fact that it implicates a core constitutional right to allow for this sort of inquiry. And here, unlike
Why not? Why is the Fifth Amendment any lesser of a right than the Sixth?
it's not that it's any lesser of a right, Your Honor, but although it is different than the Sixth in that here there's a balance of two competing public policy considerations. It's not simply the defendant's right; there's the public's interest and right as well. So it is different than, for example, the Sixth Amendment right.
Well, doesn't the public have an interest in finding out the truth of what the jury decided?
Yes.
They have an interest in a just judgment that is in fact a final outcome or final verdict here. But setting aside whether expanding it might be appropriate, it cannot be done in this case without getting into the substance of the deliberations. And I think my brother revealed that under questioning.
Yes.
There are several
Pull 'em
issues
back
with
and
it. One
pull 'em.
is, again, this jury has been discharged now for more than 4 months and has been subject to extraneous influences, potentially including harassment.
We've
or
sent
threats.
back.
Oh, God.
Race, I can't remember how many years. It was like a decade later or something. Timing's not going to be a winner for you, is it? It has to be.
No, that by itself, Your Honor, is not a reason not to do it. I'm raising it as an additional consideration or concern here. But there are others as well, which is it's not simply a matter of bringing a jury back and trying to ask them a yes or no question. That's not how juries reach verdicts. We ask them to engage in group decision-making, collective discussion, review of the evidence. So it's,
Call a poll,
Our
moron.
post-verdict inquiry is guided, and we always say to the jurors, and we tell the trial judges, you have to instruct the jurors, do not tell me about the contents of your deliberations, answer this specific limited question. And the limited question posed by the defense, and I think in the ACLU brief, is did you reach a verdict essentially on counts 1 and 3, or was it an acquittal? Right?
Correct.
I don't know that that was the specific question they proposed, but I understand.
Whatever,
Take Your Honor's point.
however
Yeah.
they phrase it, it's a limited yes/no question.
Yes, and my point is that that's an artificial inquiry. Or take, for example,
But we asked,
Did
have you reached a verdict? That in and of itself is a standard question, right? That can't be crossing the line, right? Or is it?
no, but again, I want to reemphasize the point.
Oh,
that
he's
was raised.
tanking. He's tanking.
Imagine a juror had tentatively agreed to find not guilty on a particular.
There's no remedies.
But that was subject to further deliberation or
That's why he's
consideration. Maybe the
tanking.
juror wanted to see what happened with the other charges. You now bring the jurors back and you simply ask them, I don't want to hear anything else. I just want a yes or no. It doesn't give that juror any opportunity to explain that their agreement was tentative at that point. And so it's an artificial exercise to say,
Is that what Bluford, is that, just as George asked your brother counsel about Bluford, is Bluford the answer for you, that that's what Chief Justice Roberts was saying in Bluford, that it's always tentative? Or is it's only in lesser includeds that works? Because I asked Mr. Weinberg, is there a federal case right on point that we can look to? You at least have Bluford. Is Bluford controlling? And it's the Supreme Court.
would argue that it is, and I'd actually take it one step farther, which is not only is there the concern that was raised in Bluford that the perceived agreement or unanimity here may have been the product of a very early discussion subject to further deliberation, but jurors are free to change their mind and change their vote right up until the verdict is affirmed and recorded. They could vote guilty, walk into the courtroom, and at that point change their mind and say, you know what, I think the defendant is not guilty. So even if, like counsel wants to argue, this was a final vote, this was a final decision, you still can't rule out the possibility that any juror was free to change their mind had they been required to go through the full exercise of rendering and affirming a verdict.
I mean, you can.
Is their argument what Justice Sotomayor wrote in dissent in Bluford, or is the different?
To characterize counsel's argument, I think that they are relying on that for the notion of there being an acquittal in substance, not form. Although if you look at the cases Justice Sotomayor cited for that proposition, they're all cases involving judicial rulings. They're not jury determinations. I'm not aware of any federal authority that supports the proposition that there can be an acquittal in substance but not form, or I guess more to the point, says that a state cannot impose the requirement that a verdict be affirmed and recorded. I think, if anything, Bluford acknowledges that that could be a perfectly legitimate requirement, where it said, you know, take the defendant's argument here on its own terms. It wasn't a final result, quite apart from the requirement to render a verdict or a judgment.
They're
So I think
kind of
Bluford
stuck
does
between a
support
rock and a
our
hard
case, Your
place.
Honor. I just do want to emphasize
Yeah.
that it's not only
It's
just the possibility that there
new
could be a
case
change of verdict
law.
during the deliberations itself, but even after that.
It's either new case law or hold the jury, call them back and hold them
Bluford broader than a
with
lesser
limited
included
instruction.
opinion?
I don't
Mhm.
read it that way, Your Honor. No, I read it as the general proposition that there are multiple charges, whether they're lesser included or not. Jurors remain free to go back and revisit a prior vote. In fact, I think the court said that although Arkansas was an acquittal first jurisdiction, nonetheless, the jury remained free to go back and revisit a prior vote because that's what jurors do. It wasn't inconsistent with the instructions. I want to emphasize one other point, which is, at most, what we're talking about here with these juror statements is a snapshot of the jurors' deliberations, but you cannot short circuit the verdict requirement and rely merely on
Oh,
such a
now it's
snapshot. And it's
snapshot
important
from
because it
denying
protects
it altogether.
defendants too. Imagine a
Mm.
different scenario where juror comes forward and says, notwithstanding the declaration of a mistrial, we all took a vote and we found the defendant guilty of murder. If the Commonwealth were to come forward and say, effect should be given to that vote, there can't be any serious doubt that the defendant, whether in this case or in a future case, would argue that is not a valid verdict and shouldn't be given any consideration. Unless
Except
there-
that
Your
wasn't
Honors
the
have any other
case.
questions, Commonwealth would ask the defendant's petition. be
False
denied.
dichotomy, dude.
Okay, thank you very much.
Court, all rise, please.
Interesting.
Interesting, interesting.
Now we wait for their decision.
Court stands in recess, please. Exit the courtroom.
How long are they in recess for?
No idea. While recess is on, keep an eye on the feed. You can probably mute the feed, or actually don't mute it. It's muted already. Keep an eye on that feed, and I'll chuck this other thing up on the screen.
Okay.
Let's go over here. Let me add. Why isn't it showing in my tab?
Do you want me to stop sharing mine? What are you trying to look up?
Right. Ah, you bitch. Come back now. Bring it back. Bloody hell. All right, so this is the October 26th news. Don't know how we didn't get this.
I don't think I see anything on your screen.
You should be.
I'm going to stop sharing my screen. I'll just keep an eye on it.
That might be the case.
Okay, try it again. Try to unshare and then share it again. Are you there?
Yep. Can you see it now?
Yep.
All right.
So I thought this was kind of interesting. I mean, obviously it's a little bit different, but
Right, and in this one, what I find notable, okay, we all knew she was going to be moving courts, right? But she's going to stay on the Reed trial. So, what it says here that I found interesting here, the new position in Mayor Liu's view is an enthusiastic endorsement of Judge Cannoni's competence and good judgment. A total rejection of outlandish invented stories about Judge Cannoni. It amounts to a promotion. It's also a message to Superior Court judges. If you take the hard cases, we will support you.
isn't that interesting?
Interesting.
I mean, I'm just saying, like, I saw that, and I actually saw this a couple days ago. And I mean, although it's like on a council, so I'm not sure exactly of the position, but don't you find that a little odd?
Is the criminal court, so her new gig is the chair of the Superior Court Criminal Committee.
Yeah.
Chair of that committee is second only to the Chief Justice of the Superior Court on Criminal Issues. So it's Jack Liu. I thought it was Mayor Wu. I misread that. A retired Superior Court judge and now adjunct faculty member of the UMass Lowell School of Criminology and Justice Studies. The chair of the Superior Court criminal committee consisting of Superior Court judges, the top criminal policy judge in the Massachusetts.
Oh, I think we dropped you, but in a Massachusetts Superior Court. It's a real honor and a major career achievement. I don't know, like, I mean, again, I don't think this is like super pertinent to what we're watching now, but I do find it really strange.
Right. Interesting indeedy. Yeah. I don't know how long for the results. So they're in recess. So I guess I don't really know how it works. Let me just refer back to Rich. What is
Give me
his-
1 second. I just have to jump off. I just have to
Yep, you're good.
I just have to take a call real fast. I'll be right back.
That's cool. All right. Rich is saying that's all right. Went just over 1 hour, which is unusual given time standards 15 for each side. Tough to handicap this one. Justices came out quite hostile to the fence, but asked very pointed questions to the Commonwealth. So both lawyers did well in his opinion. And that appears to be all we have so far. He's written quite a few insights as to what he's hearing them argue. So, but most of it we heard and interpreted ourselves. So,
Yeah, I mean, I'm not like it's weird because I'm not super familiar with, you know, like obviously it's like really complex law, but it's I think that they were, I think that they were equally
oh my God.
inquisitive
Yeah.
with the defense and the prosecution. I think the defense did better. I think they argued their point better than the prosecution.
Well, the defense, I think the defense elicited more questions from the panel, which is good.
Mhm.
And I think that I liked the questioning for the Commonwealth because it was all questions that we asked, like why Bev called it so quickly, and you know on what authority she was doing that. So I thought it was all very relevant. Apparently, Grant Ellis Smith is following everyone around asking if Karen if she's afraid of Aiden. He's a moron.
Oh, he's such an idiot.
No one listens to him anyway. So interesting. I did find Court TV misidentified. Let me chuck this off the screen and move us back to your screen share. The defense Court TV and a couple of commentators actually misidentified who was sitting at council table during that. And I can confirm that it was actually David Dinetti and Alan Jackson. He's got a shadow. He grew himself a bit of a shadow over the course of a couple of months. He's got a bit of a beard happening.
I mean, I think that the new attorney did pretty. I mean, I think he was really strong towards the end. I think the beginning was a little rocky.
Right.
It was a little rocky, so I'll be transparent. I think it was a little rocky in the beginning, but I think he really started to find his confidence towards the end.
Right. Sorry about the nuts on the roof, guys. I know you can hear them. If I could see them coming, I would mute so you didn't have to hear it. It's probably nowhere near as loud for you guys as it is for me. So I think it might get muted a little bit by the stream. But anyway.
Yeah, so what is the usual process that they take to come back with?
I do not know what the usual process is. Do they make a ruling today? I don't know. I think they come back with maybe questions. Like today is really just their first sort of round of arguments, I think.
So there's a couple different ones then, right?
I'm not sure. Let me just go back to what Rich said yesterday about the whole deal. Where all we can hear is your mouse going off.
Oh, I'm sorry. I need to.
Right, Rich says argument for lawyers for the common justices to interrupt. Each side of 10 minutes.
I think we lost you there for a sec.
So just looking for what the process is.
Sorry, I'm just gonna like mute myself on and off. I just have to do both different things. Sorry about the mouse.
It's okay. Do what you got to do. I know you're trying to work in the background as well. So
still
Very
here.
important for them to have a factual full record. And I think this is it. I think what's going to happen now, and I could be wrong, and it might be best to be watching Melanie's stream for legal advice, like legal procedure. But I think, just by wild guess, they will come back and ask any final questions. I don't think they'll rule from the bench. That's my guess.
Oh, that makes sense.
Yeah.
That makes sense.
Just blame the nut.
Yeah, I'd be interested. I would.
All right. Well, killed two birds with one stone today, didn't we? So I will cut that up into 2 videos and separate them out so that they don't get mixed up. Well, thank you very much for watching. Last day tomorrow of this trial, so day 9 of the Leilani Simon toddler in the trash trial. So tomorrow we'll be doing closing arguments and then rebuttal, jury instructions, and then the verdict. Oh, coffee's so good. I love coffee. Hello, Mr. Udahef. You just missed 2. We did a double dipper. No, we're just finishing. We've done day 8 of the Leilani Simon toddler in the trash, and we even covered the Karen Reid the SJC live stream where they were arguing the appellate counsel ruling for the jury to be polled and the double jeopardy issue, which was good. So I've sort of got both on this stream, which I'm going to, once I end this stream, I'm just going to go back, cut them into 2 and put up the Karen Reid one separately and cut it out of this one. So sorry. So if you're interested in appellate court and the arguings, Weinstein was arguing for the cause. Yannetti was there, and they haven't made a ruling as yet, but they were trying to. The appellate counsel was trying to get Weinstein to give case law, but there isn't any case law federally for this particular issue. So we'll see how that goes. But sorry, you'd have. Sorry, Don. What time is it over there? What, 11:30 now in the morning? Lunchtime or coffee break? Well, it's 2:30 in the morning here, so I'm going to have a quick coffee and I'm going to finish this editing and go nice. All right, my lovelies. So tomorrow is the final day of this trial. So we're doing closing arguments and jury instructions and verdict. And then Friday, I'm hoping that we have some news on Ty. And then Saturday's the podcast. So busy. Stay tuned, stay warm, stay happy, stay healthy. And I shall see you same time, same place, same batch. Arrivederci. Bye.
Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests. Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule and the defense rests.